A2 above Joshua. A3 number artificial Michael.
May it please be Your Honor, Joseph Lamatu for prosecution. And I'm appearing together with Jonathan Wabani, by his hand, the Chief State Attorney's Worship, and Miss Sabina Gileke, Senior State Attorney. Your Honor, A1 and A3 but A2 is not here. And for A1 and A3, Mr. Michael Amasebu, Mr. Jude Yamkama, and Mr. John Musime jointly appear for them. Your Honor, A2 has still not returned to court. Although we served a criminal summons that were issued by this honorable court. But appearing for him is Mr. Paul Kutesa, Your Worship. The case is for ruling on the bail application that was made by accused number 1. We are ready to receive the ruling.
Your Honor, with the indulgence.
Just a moment.
Your Honor, hearing for A2 about Joshua. Your Honor, it is not here. Your Honor, A2 about these proceedings. A2 learned about these proceedings through the media, because he was not, when the matter came up last Thursday, he was not summoned, he was not arrested. He had been on bond, on police bond, which was not cancelled, he was not caught by the police. So that's why he didn't come last Thursday. Your Honor, I've heard that the summons were issued by this court, but they have not been served on him personally, because I believe he took leave from his office Wednesday last week, 5th of April, on medical grounds, because his wife on that day had got a miscarriage and he was had a serious health challenge. He was admitted in high dependence unit at Nakasero Hospital. He is the sole person who has been attending to her.
Is that the reason for non-attendance today?
Yes, Your Honor, and I'm going to explain to you.
No, it's because I look at you well.
Yes.
In other words, pardon me.
Yes, Your Honor. The accused person is currently, as I speak, attending to his wife who got a medical condition and has been in HDU, high dependence unit. He's the sole caretaker. When he learned about these proceedings, he instructed us yesterday. We found out that they are coming up today. And Your Honor, he could not come because he's the sole person attending to this person who is seriously ill. He's seeking the indulgence of court to come within the next 2 days. He has made arrangements to get another caretaker who I believe will be available tonight, and he will be able to attend to court. We accordingly, Your Honor, pray that the court gives him indulgence, extend those summonses that were issued, and at the earliest convenience, even tomorrow, Your Honor, he will be able to appear in court and answer to the charges that were leveled against him. I so pray, Your Honor.
Defense on behalf of the council, on behalf of and can I believe that you're ready to receive the ruling?
That's correct, Your Honor. We are ready to receive your ruling.
The applicant, that is A1 Nachitutu Merikoreti Kimono, made this application through her lawyers, relying on Articles 23, Sub-Article 6A and 28, Sub-Article 3 of the Constitution, Section 75 and Section 77 of the Magistrates Court Act, the High Court Anti-Corruption Bill 21, and the court lines practice the application Council on the conditions for consideration for bail or grounds for bail application as per the guidelines, and I'm going to ask that I skip the submission by counsel. We were all here, we had them. And then the prosecution also has a team of prosecutors that is representing it, led by Madame Josephine, who argued out the reply that is in opposition to the application, majorly relying on the section 77 of the Magistrates Court Act and the affidavit that she adopted as part of her submission. And this is where this court's mind begins from. To begin with, this court takes note that during the submissions, there were lots of sentiments that kept popping out, but this court will not be swayed away by any. What should be noted is that all persons are equal before the law. All persons that are alleged to have come into conflict with the law enjoy the doctrine of presumption of innocence, and that bail is granted at the discretion of court. Much as bail is granted or denied at the discretion of court, this discretion must be exercised judiciously, and this is why there are conditions provided for under the law for court to consider when entertaining the bail application. As mentioned by counsel for the applicant in arguing the application, there are conditions to be considered as provided for under Section 77 of the Magistrates Court Act, the High Court Anti-Corruption Division Case Management Rules 2021, and the Constitution, Bail Guidelines for Courts of Judicature Practice Directions 2020. Before going into the merits of this application, this court takes note that for the applicant in rejoinder, counsel for the applicant prayed that court should not rely on the affidavit in opposition of bail, and actually invited this court to strike the same off its record for the reasons already seen, that is as per the submissions. In this regard, first and foremost, this application is an oral one, which is permissible in magistrates' court, and the reply to the same is also oral. So for the respondent to be able to make a substantive reply to the same, there are some evidence that can only be adduced in court by way of an affidavit, since in the absence of the same, such submission that includes evidence in the absence of an affidavit remains evidence at bar, which is not admissible. So it is not strange or out of order that in this application, the prosecution is relying on an affidavit to raise its objection to the bail application. The other aspect is that the condition or considerations or grounds for bail are not a secret. They are embedded in our laws as mentioned above. Because evidence may come out at the level of reply, at the level of reply that is detrimental to the applicant's application by virtue of guideline 13, sub-guideline 4 of the Constitution, 8 guidelines for courts of judicature, practice directions 2020. Courts are called upon to give the applicant an opportunity to rebut the claims of the prosecution before court decides whether to grant or deny the applicant bail. So the submission that this affidavit was filed before the application was made has no merit. Then as to the contention that the applicant's lawyer raised in regard to whether the deponent of the affidavit was able to do all that is claimed he did, like appearing before the commissioner of oath and doing all that was done within the short time, instead of counsel wondering whether this was magic and submitted, he should have made an application for the deponent of this affidavit to appear in court for him to examine him. I find that his submission in regard to the integrity of the affidavit has no merit. In regard to the annexures not being exhibited, looking at the same, they were unmarked A, B, C. So in conclusion, in regard to the integrity of this affidavit before this court finds that the same is proper before it. Considering the submissions made in objection to the bail application in witnesses and inquiries, this court will not have been made. Delving into these will only be seen to be touching on the presumption of innocence. The submissions went deeper than they could have gone. In objection, the prosecution submitted that the applicant did not heed to summons, though to summons through and from the Right Honorable Prime Minister to appear before the Directorate of Criminal Investigations, that is a Uganda Police Force, as reflected in paragraphs 8 and 7 of the affidavit in opposition to the bail application. I must concur with the application as submitted in rejoinder, or I must concur with the submissions as made in rejoinder by her counsel that there is no proof of service upon the applicant, and so this ground of application has no merit. There is also nowhere that the prosecution probably simply indicated that she did receive the document as can be seen on the documents. Getting to the submission that court should consider that the offences involve that the offences involve no violence, this court sides with the prosecution that this is not a condition in application in offences of such a nature, and especially the offences that this court handles. For the ground of the possibility of delay, the applicant has not presented to this court any evidence by way of statistics to back up this claim, and as well noted by the prosecution, this court is guided by the High Court Anti-Corruption Division Case Management Rules 2021, which provides for timelines from when matters are first registered and guides on the procedure and the time to be taken at each stage. Moving to the sureties, counsel for the applicant, among other statutes of laws, relied on the High Court Anti-Corruption Division Case Management Rules as one of the laws upon which the application is premised. Looking at Rule 7A, the same provides that the court shall, before considering any person to stand a surety for an accused person, determine that the person has the capacity to compel the accused person to attend trial. Already as well submitted to by the prosecution, surety number 2, Mr. Simon Mulongo, is said to be a former Member of Parliament, and a diplomat working as a special envoy to the African Union. Pardon me there. Already as well submitted to by the prosecution, surety number 2, Mr. Simon Mulongo, who is said to be a former member of Parliament and a diplomat working as a special envoy to the African Union, falls short of this requirement as the nature of the office that council claims he holds would require him in and out of the jurisdiction of this court, which is out of the country, hence compromising his ability to be able to compel always ensure that the applicant attends court whenever need arises. For the submission based on the sureties 2, sureties 3, Honorable Said Wambede, and 4, Dr. Joel Wandawa, being friends to the applicant, and their capacity to compel her to attend court not having been demonstrated, this court finds that as per the record, the applicant's counsel did explain the friendships, so this objection has no merit. Then turning to Rule 7, Sub-Rule B of the terms of the bond. I do concur with the prosecution on all fours in this regard and find that the case laws as cited are very relevant to this matter. Council submitted that these are not economic as there is no monetary value attached. Indeed, there is no monetary value attached to the iron sheets, but Rule 7B of the above rules are very clear. It does not restrict itself to economic crimes, but also needless to say, definitely the iron sheets have value, including monetary value. It is a requirement that financial capability of the sureties are demonstrated, and this was clearly elaborated upon in the case of Tefera, which I had already cited earlier on, in the submission as made by the state, which is on record. Bank statements can be presented, and all employment identity cards or documents showing registration, documents showing that a business is licensed, generally a document that shows that whatever the person thinks he does to earn a living generally generates some income. It is on the surety to Honorable Wambede Said Chizanji Masa, as the names appear in the employment identity card, who has presented before this court proof of employment as the current member of Parliament from Bale City. I must say, the earnings of MPs is sufficient for one to be considered as a surety, especially in this court. I find that he is the only surety who passes the test of Rule 7, Sub-Rule B of the above rules, and he is the only surety that this court finds substantial. For the rest of the sureties, mere mention of places of work, designation, being honorable, prominent persons in society is not sufficient. In light of all this, I find surety 1, Mr. Chitutu Michael George, surety 2, Mr. Simon Mulongo, surety 4, Mr. Wandawa Joel, not substantial. Before I wind up, this court is in receipt of such information in regard to the pieces of land mentioned in the submissions above, by both the prosecution and applicant. From the information that I received, both sides actually went for a search. So both sides gave me results of their search, and both sides confirmed to this court that the titles that were presented before it are genuine, and have confirmed that the said pieces of land belong to A1. Needless to note, there appears to be a new aspect that arose in the letter that is by the prosecution, and that was value of land. That did not appear when we were sitting here, and this court will not delve into the same. In conclusion of this application, therefore, this court finds no merit in all the grounds of objection raised by the prosecution, save for those raised in regard to the sureties not found to be substantial, as they do not meet the requirements of Rule 7b of the rules of this court. Much as this court finds that surety theory is substantial, this court declines to grant the applicant bail, as it requires at least more than one surety. Let the applicant go back to the drawing board and find other sureties that probably pass this test and add onto the one that court has found substantial.
Your Honor, we are most obliged and thank the court for its wise ruling.
I'm going to remember your name.
John Musime. Your Honor, my name is John Musime, one of the advocates for A1 and A3. Your Honor, I raise on matters to do with the proper management of this matter at the earliest opportunity. And it goes to the right to a fair trial of especially A1. Your Honor, the first...
Slow down a bit.
Yes. So Your Honor, the first thing to do with the rule of sub judice, or at least of the rule of sub judice by the DPP. Obviously, Regulation 20 of the Advocates Professional Conduct Regulations.
Regulation 20
of the Advocates Professional Conduct Regulations. Just looking for it for reasons of court. Just 1 second. We usually have another edit. Your Honor, since the court has it, I pray that I read through it. It says, an advocate shall not make announcements or comments to newspapers or any other news media, including radio and television, concerning any pending, anticipated, or current litigation in which he or she is or is not involved, whether in a professional or personal capacity. Now, Your Honor, the office of the inspected the office of the DPP runs a Twitter account. And I have produced to court extracts of tweets that the office of the DPP has published. Just publishing them, Your Honor, while they prosecute this matter. Even merely publishing, just the act of publishing on social media without more contravenes Regulation 20. And it prejudices the accused persons because the DPP is prosecuting them twice, in the media and in court. Article 28 is clear. Ugandans can only be prosecuted in a court of law, not on social media, as the DPP is choosing to do. Indeed, when we left here, the spokesperson of the DPP addressed an impromptu media interview where she gave an interview directly on this matter, what their strategy is, who they are going to arrest. Well, I would like to take you to highlight a few things in the extracts that I provided court. The day before we came here, that office published a document they called a charge sheet. They did not even have the courtesy of sharing the same with us. The document was not signed by court, but they declared it a charge sheet. We believe that the document only becomes a charge sheet when the court sanctioned it. Secondly, on this very Twitter handle, Your Honor, we humbly ask to refer court to the document we just given, maybe you can follow with us. So the top one, you see that the part we've highlighted, this is what the tweet said. The Office of the Director of Public Prosecutions, ODPP, has sanctioned charges of corruption and, I highlight, conspiracy to commit a felony against Honorable Mary Tutu. Now we later saw the charge sheet. It does not have any charge of conspiracy to commit a felony. The one offense is created in section 390 of the Penal Code Act. The other is created in section 309. In other words, this is false. You cannot have a prosecution where the DPP is telling falsehoods, publishing them. That is prejudicial to the accused person. And again, all this goes through the whole thread of what they are saying, who they arrested, and what. This is totally unprecedented and prevalent by. I'm saying this kind of conduct is unprecedented. We pray that court, in doing two things, managing the process of this court, so that we have only one magistrate and one trial inside the courtroom. And to protect the rights of the accused person, pray that you direct that the DPP forthwith stops making any other tweets and in this matter. They stop calling press conferences and addressing them on this matter. And before I take leave of the office of the DPP, it is interesting, Your Honor, that Facebook remains banned in Uganda. But when you look at the extracts of these tweets, somehow the office of the DPP is on Facebook. And you not know whether they want to consider prosecuting themselves. But that is as far as the office of the DPP is concerned. Relatedly, Your Honor, related to this, Your Honor, the defense thanks and appreciates our colleagues in the Fourth Estate. Because like us, we know that they are doing their professional duty and they are earning living and all of that. However, we must protest.
Members of the Fourth Estate, as you do your work also, be very alert to what you say, because it's not directed to you.
Yes, we thank our friends in the media. They are professionals like us. But we request court to give a direction that we all behave professionally. There are professional guidelines on